And when you hear these arguments from John Sauer, just keep in mind that a federal judge, an unelected, black-robed, inferior district trial court judge, John Sauer is before SCOTUS because the federal judge told the president of the United States, you don't have permission to fire anybody unless one of the other co-equal branches of government says you do, that there are no core and plenary powers to the president under Article 2 of our U.S. Constitution. So this decision is in the matter of Donald J. Trump, president of the United States, versus a union, the AFL-CIO and a bunch of other unions. Never been a fan of the unions, less of a fan even now. The unions of federal employees that Trump is trying to fire. Let's see, parties. So virtually because this was a nationwide injunction by this loon of a judge, it covers the entire federal government. Trump's not allowed. And look at all the agencies. This is the list of agencies. Virtually everybody in federal government is a party to this suit. It's madness. Okay, let's start now with John Sauer, the unelected black-robed, tyrannical, inferior federal district trial court judge, entered a nationwide injunction that bars nearly the entire executive branch, 19 agencies, including 11 cabinet departments, from implementing an executive order that directs them to prepare plans. That's what's enjoined, not even the firings, merely preparing plans for how to execute lawful reductions in the size of the federal workforce. This federal judge said, no, I'm not going to allow you to even prepare plans for how to fire people that are an unnecessary burden on the back of the taxpayer. That injunction rests on the indefensible premise that the president needs explicit statutory authorization from Congress to exercise his core Article 2 authority to superintend the internal personnel decisions of the executive branch. Keep in mind, folks, that the key in management, in superintending employees, is not really hiring. When you hire someone, you don't really know whether or not they're going to work out. You're taking your best guess. The real power in management is the ability to fire people. If you can't fire people, you've all worked in corporations before, I expect. If you can't fire someone, what control do you have over them? None. What are you going to hear? You're not the boss of me. Well, you're not the boss of them unless you can fire them. So who's the boss of these federal employees? If it's not Trump, if it's not the Article 2 executive branch president, who is it? Is it the hundreds of people in Congress? Is it the even more hundreds of federal judges? These people are left unaccountable to anybody. It's outrageous. Like a mere federal employee has some kind of independent authority under the Constitution to their job forever. Not even the president of the United States has anything to say about it, according to this judge. In fact, he's not even allowed to prepare plans for how to reduce the federal workforce lawfully of unnecessary staff, larded upon us by President Joe Autopen Biden.
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive, adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
John Sauer continues. Under our Constitution, the executive power, and by the way, he's quoting the Supreme Court here. Under our Constitution, the executive power, all of it, is invested in a unitary president who must take care that the laws be faithfully executed. That's seal of law, which is a U.S. Supreme Court decision from 5 years ago. Controlling the personnel of federal agencies lies at the heartland of this authority. The Constitution does not erect a presumption against presidential control of agency staffing, and the president does not need special permission from Congress to exercise core Article 2 powers. Every branch has core and plenary powers that the other branches cannot touch. Checks and balances are not infinite. There are things that each branch can do that the other branches have nothing to say about. If Congress overrides a presidential veto, nothing the president says or the courts say can change that. If the Supreme Court decides to hear a case, the president can't prohibit that, nor can Congress. If the president decides to pardon someone, neither Congress nor the Supreme Court or any federal court has anything to say about that. These are core and plenary powers of the Constitution over which the other branches have no checks and balances. Not everything is subject to a check and balance. Not everything is subject to judicial review. There are things that are beyond judicial review. These federal courts do not have the infinite authority they claim. They have, as must be true in any republic answerable to the people, these federal judges must have limited authority, limited jurisdiction. Not infinite. John Sauer continues. The district courts, the unelected black-robed tyrannical inferior federal district trial court's injunction violates these bedrock principles and other well-established doctrines. As Judge Callahan explained below, dissenting from the Ninth Circuit's denial of a stay. So this went from the trial court to the Ninth Circuit Court of Appeals, which denied to stay this insane injunction. And that's why we're now at the Supreme Court. As Judge Callahan explained below, dissenting from the Ninth Circuit's denial of a stay of this crazy injunction, the president has shown a likelihood of success and irreparable harm with respect to this sweeping preliminary injunction that strips the executive of control over its own personnel. Plaintiffs improperly bypassed the comprehensive administrative scheme that Congress has enacted to handle federal sector labor and employment disputes. This is things like the National Labor Relations Board, the Merit Protection Service Board. As I say, federal courts have limited jurisdiction. They only have the jurisdiction that Congress allows them to have. And Congress has passed specific statutes that strip from the federal district trial courts authority over federal employment issues. There are separate administrative processes for that because Congress did not want the federal courts dealing with federal employment issues. They explicitly took that authority away from the federal courts, though you wouldn't know it. Looking at the federal courts, they think they have infinite authority. The unelected, black-robed, tyrannical, inferior district trial court judge erroneously concluded that the executive, the president's actions likely violate separation of powers, and they did that without making any finding that any agency's reduction in force is likely to violate any statute, and despite the president's constitutional power over the executive branch. This Supreme Court recently intervened to stop another unelected, black-robed, tyrannical, inferior district trial court from undoing the effects of the lawful, large-scale termination of probationary government employees Excuse me, folks. You, SCOTUS, should take the same course here, where this injunction sweeps far more broadly to cover most of the federal government and even restricts the president in planning personnel actions pursuant to presidential direction. As this Supreme Court has recognized, federal courts do not possess a roving commission to exercise general legal oversight of the executive branch, including its personnel practices. Furthermore, it clearly is within the president's constitutional and statutory authority to prescribe the manner in which his subordinates conduct their business, and this mandate of office must include the authority to prescribe reorganizations and reductions in force. In February, pursuant to his lawful authority to direct executive agencies regarding personnel decisions, after all, the executive agencies work for the executive branch president, Trump issued an executive order directing agencies to promptly undertake preparations to initiate large-scale reductions in force consistent with applicable law, including laws that mandated the performance of certain functions or require certain agency subcomponents. The president's order rested on firm legal footing and followed a long historical tradition. For at least 150 years, Congress has recognized the executive branch's authority to carry out reductions in its workforce as the need arises, subject to statutory preference for veterans and other factors. Guess who fired people, by the way, folks? Clinton fired people. Obama fired people. That was fine until we get to President Trump term 2. The executive, the president, has repeatedly exercised reduction in force authority. Oh, they guessed where I was going, John Sauer. In 1993, for example, Clinton ordered all federal agencies with more than 100 employees to eliminate not less than 4% of their positions within 3 years, aiming for government-wide reductions of 100,000 federal workers. Nearly 3 months after President Trump issued his order, however, several labor unions, advocacy groups, and local government respondents think, folks, these are NGOs suing our president using our tax money. Sued the president, almost every executive department, and other federal defendants in the U.S. District Court for the Northern District of California. Guess what that means? Northern District of California. That means San Francisco. Judge shopping? Anybody? Why isn't this in a federal court in Oklahoma? Do you imagine? I wonder. These plaintiffs sought to enjoin, have an unelected, black-robed, tyrannical, inferior district trial court judge freeze the Article 2 executive branch president whom we elected, the whole of the American people, to carry out our political will. They asked this judge, a mere judge, to freeze the implementation of the executive order and a follow-on memorandum. The district court quickly granted a universal injunction, first as a temporary restraining order, then as a preliminary injunction. So that alone delays Trump for initially a month and then indefinitely for the duration of the litigation, which could be years. For years, a mere federal court judge is telling the president, you're not even allowed to prepare plans for a reduction in force until I say otherwise. This enjoined froze the president from proceeding with any existing or future reduction in force, even ones that have no effect on the plaintiffs before the court. Again, universal injunction. That same unelected black-robed, tyrannical, inferior district trial court judge refused to pause this freezing of the president, and a divided panel of the Ninth Circuit also declined to do so. This Supreme Court should freeze the freeze. This Supreme Court should stay the district court's injunction, which suffers from multiple fatal flaws. To start, respondents cannot directly challenge a reduction in force for at least 4 reasons. Reductions in force, 1, reductions in force are indisputably permitted by federal law. 2, the president's order says reduce in force only as consistent with the law. 3, many of the reductions in force have not even yet been finalized, so there's no harm. And 4, any challenges to the risks themselves are channeled into special administrative and judicial review schemes concerning federal employment. So the court doesn't even have jurisdiction over this yet until you exhaust the administrative remedies. Facing these obstacles to any direct challenge to the reductions in force, the respondents have instead manufactured an objection to the executive order, but respondents cannot end run all those obstacles merely by challenging the executive order for both procedural and substantive reasons. Procedurally, an objection to a RIF is also subject to Congress's preclusion of district court jurisdiction over federal employment. Again, Congress has taken away from the inferior district trial courts jurisdiction over federal employment. And regardless, their inability to directly challenge agency RIFs does not entitle them to instead attack the executive branch's whole program by seeking to enjoin implementation of the executive order and memo government-wide. So it looks like a little smoke and mirrors is going on here. It looks like the plaintiffs, the unions for these federal employees, recognize they can't ask the judge to interfere with the reduction in force per se, because that's obviously allowed. So instead, they're saying, well, it's not the reduction in force we object to, it's the executive order and memorandum that orders the reduction in force. That's what we object to. I mean, this is obviously an insane and completely pretextual attack on the core and plenary powers of the Article 2 executive, reinforced by delegation of authority from Congress. Substantively, the general direction and guidance contained in the executive order and memo are unquestionably lawful. Because the entire executive power belongs to the president alone, he must have the power of overseeing and controlling who executes the laws on his behalf. And again, they're quoting a Supreme Court decision from only 5 years ago in support of this claim. That includes the power to effectuate policy objectives by directing agencies to exercise their statutory authority to conduct RIFs, as long as it is done in a manner that is fully consistent with the law. The unelected black-robed inferior district trial court turned the constitutional structure upside down by treating as supposed evidence of unlawful action the mere prospect that agencies are acting at the direction of the president and his team. Equally meritless is the unelected black-robed tyrannical district court's objection that the president may not, without Congress, fundamentally reorganize the federal agencies. The executive order makes clear in proposing reductions in force that agencies should ensure that they do not eliminate any subcomponents that are statutorily required or prevent the performance of functions that are mandated by statute or other law. The president does not need additional statutory authorization to direct agencies to conduct reductions in force to further reorganizations within the statutory bounds set by Congress already. Here, the employees or their unions failed to show, and neither court below us, below the Supreme Court, found that a single agency's organic statute would be violated by any proposed reduction in force. Exacerbating matters, the district court joined the parade of courts entering improper universal injunctions, extending relief far beyond what was necessary to redress the alleged injuries of the plaintiffs actually before the court. It enjoined almost 24 executive entities, plus anyone acting under the president's authority, from implementing any reduction in force, regardless of whether the termination of the employees would have any effect on the actual plaintiffs. That abuse of equitable power alone calls for a stay. Turning to the equities, the unelected black-robed tyrannical district court's flawed injunction inflicts ongoing and severe harm on the government, calling for this court's intervention. Now we're getting to the separation of powers violation. An instant, even a mere instant, of a federal court infringing on the core and plenary powers of the Article 2 executive branch causes immediate irreparable harm to the Article 2 executive branch. This injunction interferes with the president's internal operations and unquestioned legal authority to plan and carry out reductions in force, and it does so on a government-wide scale. More concretely, the injunction has brought to halt numerous in-progress RIFs at more than a dozen federal agencies, sowing confusion about what RIF-related steps agencies may take and compelling the government to retain at taxpayer expense thousands of employees whose continuance in federal service is deemed not to be in the government and public interest. Although the injunction permits agencies to engage in their own internal planning, it hamstrings those efforts by barring the involvement of OPM and OMB. These are the government agencies that are like, think of them as the HR departments for federal employees. And this is a bizarre rationale. So the lower court that issued this injunction said, hey, it would be fine for like the EPA to plan a reduction in force, but it's not allowed for the president to order that. Well, then who does the agency answer to? If America is supposed to be a government by the people, for the people, of the people, for the people, who does that government respond to? These agencies don't even respond to the president? That's madness.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.